All right, let's get right into it. We're about to explore a critical legal question facing Singapore. But we're not just going to look at a law. We're putting the law itself on trial. And at the very heart of this case is one single, profound question. Does the law truly see an animal as a feeling, sentient being?
You know, this single sentence from a legal analysis, it's not just a bunch of fancy jargon. It's a powerful indictment, a lacuna that's a gap, a void, a massive hole. And what it reveals is that the very foundation of Singapore's animal protection law is, well, broken. There's a silence where a clear voice needs to be.
And here's where it gets interesting. While the written law has been silent, Singapore's courtrooms, they've started to speak up. They're creating a kind of quiet revolution, one case at a time. So in this explainer, we're going to put that law on trial. Look at the evidence, the key cases, and the final verdict that's looming just over the horizon.
Okay, let's call our first piece of evidence to the stand, the law itself. What is actually written down and, more importantly, what is so critically missing?
So check this out. Here's the central contradiction. The Animals and Birds Act is supposed to be the main shield for animal welfare, right? It prohibits causing unnecessary pain or suffering. It even forces a duty of care on owners, and the penalties can be really serious. But here's the fatal flaw. It demands that we protect animals from suffering, but it completely fails to define what a suffering creature actually is. It's a huge blind spot.
And this slide just perfectly illustrates the conflict at play here. You've got these two laws running side by side. The Animals and Birds Act, which is supposed to be about welfare, and then the Control of Dogs Act, which is really just about public safety and keeping order. It creates this legal tug-of-war, and an animal's well-being is stuck right in the middle.
So this abstract legal conflict, it was about to become devastatingly real. Let's bring in our Exhibit B, the story of a single dog whose case would change everything.
This is the story of Hugo. Now, Hugo wasn't beaten. He wasn't starved, not in the way you'd think. He was a Shetland sheepdog, and he was confined to a cage just 61 centimeters long. His suffering wasn't from a physical blow. It was from the crushing day-in, day-out reality of his confinement, and his case forced the courts to finally confront the law's deep, uncomfortable silence.
So the crucial point is what the judge decided. Just look at these statements. The court declared that welfare is not just about physical health. An animal can look perfectly fine on the outside, but be suffering immensely on the inside. The judge inferred Hugo's suffering from his conditions alone, and that set a huge precedent. Psychological harm is just as real as physical injury under the law. This was the moment the judiciary started to fill that void the legislature had left open.
And listen, Hugo wasn't just some anomaly. He was a real turning point. This timeline shows a clear, deliberate pattern. It started way back in 2010 with the Butters case, which laid the groundwork. Then came Hugo in 2016. And now, in a 2025 case, the court explicitly used the term sentient creatures. You can see it right there. Singapore's judges are systematically, case by case, building the legal argument for animal sentience.
Now, no trial is complete without some expert witnesses, right? So let's call to the stand other leading nations and see what the global verdict is on this very issue. How does Singapore's approach stack up against the rest of the world?
First up, the prosecution calls the European Union. Their testimony? It's Article 13 of their founding treaty. And get this, it's not a suggestion. It's a mandate for all member states. It starts with this fundamental premise. Since animals are sentient beings, for them, it's not a debate. It's an established fact that all law flows from.
Next, we have France. Back in 2015, they amended their civil code in a really powerful, symbolic way. Animals were no longer legally classified as movable property, like a chair or a car. They were elevated to a whole new status, living beings gifted with sentience.
The United Kingdom went even further. They passed a whole new law, the Animal Welfare Sentience Act. Its entire purpose is to formally recognize animal sentience in law and to create a committee to make sure that fact is considered in all future government policy. And finally, Spain. In 2023, they not only recognized animals as sentient beings, but took it another step, acknowledging them in certain legal situations like custody disputes as family members. I mean, the international precedent is just overwhelming. It's crystal clear.
So, with the domestic cases heard and the global evidence presented, we've arrived at the closing argument. What does all of this mean for Singapore right here, right now?
Let's be very clear. This is not just some theoretical legal debate. The data shows us the real-world stakes. In 2024, an average of 6 animals were known victims of cruelty every single day. That's over 2,000 reported victims in just 1 year. This legal ambiguity isn't abstract. Its cost is measured in real, daily suffering.
And advocacy groups like the SPCA draw a direct line connecting this suffering to the very legal gap we've been talking about. They argue that the framework's failure to recognize sentience is the root of the problem. That legal silence creates both the motive and the opportunity for this harm to happen.
But now, the case for reform is being formally brought to the table. A major white paper has demanded change. The government has agreed to hear the case, scheduling a full review of the Act for 2026. And there's a clear, direct solution right there. Just amend the law to explicitly define an animal as a sentient being.
So, the evidence is in. We've seen the judicial precedent, the international standards, the scientific consensus, and the public advocacy. It has all been presented. The arguments have been made, not just in courtrooms, but in official papers and public debate. All the pieces are now in place for a final decision.
And so, this is where we're left. The 2026 review isn't just another policy update. It is Singapore's verdict on animal sentience. The evidence has been presented. The arguments have been heard. The only question that remains is how will Singapore rule?